So, any questions on this portion, this initial portion of the session? Anybody wants to add something, ask something? If not, I would hand over to Maurizio very quickly, so that we can try to gain a few seconds. Thank you very much. Slides. There you go.
Okay. How to shift from one slide to the other? Okay. Thank you very much. Good afternoon to everyone. The title of my very short speech ends with the question mark. There will be other questions during my speech and probably few answers, but what I would like to transmit are just few ideas which I found extremely interesting in preparing this intervention. We all know that maritime law has created an extremely sophisticated and organized framework of rules to regulate the life of the ships and the liabilities of the persons dealing with ships. We have a number of conventions, which I shall have listed here very quickly, on collision, salvage, arrest of ships, liens and mortgages upon vessels, limitation of liability of owners of seagoing ships, carriage of passengers on seagoing vessels, removal of wrecks, which will enter into force next year, and applies to ships which have become wrecks because of a casualty, the International Convention on Civil Liability of 1992, the Fund Convention, the Supplementary Fund Protocol, which all apply to ships, the 2001 International Convention on Civil Liability for Bunker Oil Pollution Damage, which applies to ship. All the above mentioned conventions only apply to ships and not to offshore installations, which are not ships. On the contrary, the liability deriving from the employment of shore platforms or installation is still governed by a primitive, chaotic, and disorganized set of rules. Therefore, it is imperative to understand what is a ship and what is not a ship, especially in the light of the continuous technological progress which produce every day new objects which resemble a ship, which work on the sea, but to which the above set of rules does not apply. We are all facing, consequently, the traditional problem that human beings constantly face of definition. The definition process can start with this demand. What is a ship? What is it? Which are the characteristics of the ship? Must be floating, of course. Must have an independent motive power, a steering equipment, but it is not likely that this method can produce satisfactory results. We are more likely to obtain some interesting result if we think about the purpose and the destination of the ship. So we can define the ship not for what it is, but for not what it is, but for what it is. We know that this is not an easy task, and we know that we can even renounce to find a shared definition of ship based on the nature or on its destination, and accept the final conclusion that the ship is what a legislator in a certain time, in a certain context, decide to be a ship. We also, I forgot these slides completely, sorry. These are the strange objects we were talking about. These are the criteria. We also know that there has been an interesting phenomenon which applies only to ships and not to other objects working on the sea, which is the phenomenon of the personification of the ship, which is probably unique in modern times. We know that in English language, the personal pronoun used to indicate a ship is she and not it. The vessel has a date of birth. She's baptized. She gets nationality. She has class. Sometimes she has impatience when she waits for the birth. Most of the time she's a tramp, like a lady. Sometimes she's blamed for what she does, especially when she eats another ship. She can even be put under arrest. She has sisters, and she has a husband. And certainly none of the above human expression apply to a platform. Platforms are just things, not human beings, pieces of iron or other inanimate materials which are used by men at sea as factories, refineries, deposits, well. Still, such profound difference in our mind and in our vision of the world is not sufficient to clearly define what a ship is and what is not under a legal point of view. There are even objects which are a sort of mutant creatures. Ships at the beginning of their lives, but subsequently transformed to become something else and to pursue scopes which are different from navigation and transportation. We have an article in our Code of Navigation which defines the ship. Is Article 136. Ship means any construction having as a destination the transportation by waters, also for the scope of towage, fishing, leisure, or other scope. Such definition renounces to identify any typical characteristic of the ship, not even that of being floating. The primary and essential utilization of the ship is the transportation by water. Then there are secondary and non-essential scopes like towage, fishing, leisure. If we try to read between the lines of this legal definition, we can see that our legislator wanted to suggest that a ship is a ship if its scope utilization is the transportation of person and things, which is the movement on waters from one place to the other. However, the definition also wanted to suggest that not only passenger ships or cargo vessels are ships. A ship is still a ship if the final scope of the transportation is not to transport persons and things, but to achieve different results like fishing or just enjoy life at sea. The Italian courts tested the above definition of ship in a case of 1994 arising from a dispute whether a floating dry dock like this one, which had been towed from England to Syracuse, could be considered a ship for the purpose of payment of VAT. The Italian court held that this object was not the ship. The characteristics of being floating, movable, and fit for the navigation were not sufficient to qualify the same as a ship because its specific destination was not the navigation. And this is the 1992 CLC Convention defines the ship in a complicated matter, which is the result of different modification of the text of law. The two first lines are more reassuring because they read, ship means any seagoing vessel and seaborne craft of any type whatsoever, constructed or adapted for the carriage of oil in bulk as cargo. Then there are the additional lines which complicate the work of the interpreter and which I leave for the discussion later, not to waste too much of my time. The judgment of the Greek Supreme Court is very important and must be remembered at this stage. This was a judgment which was issued in June 2006 by the Greek Supreme Court in the case of a waste and oil reception facility which was named SLOPS, and is probably the only real precedent in this matter. The SLOPS was originally designed and constructed for the carriage of oil in bulk as cargo. In 1995, it underwent a major conversion, in the course of which the propeller was removed, the engine was deactivated, with a view to converting the status of the craft from a ship to a floating oily waste receiving and processing facility. This creature, this mutant creature, became a floating storage unit after being born as a ship. There was an explosion, it caught fire in the port of Piraeus. The 1992 Fund Executive Committee decided that the craft was not to be considered a ship under the 1992 Convention, and the compensation could not be made by the IOPCF fund. The Supreme Court, the Greek Supreme Court, held just the contrary. According to that court, the sloops had the character of a seaborne craft, which, following the modification into an FSU, it had the ability to move by being towed with a consequent pollution risk without it being necessary for an incident to take place during the carriage of oil in bulk. Not surprisingly, such opinion is not unanimously shared. IOPCF entrusted Professor Loewe, Queen's Counsel, to prepare a study, which can be found on the website of IOPCF, which is extremely interesting, reaching the conclusion that the definition of the term ship contained in the 1992 Convention is deliberately linked to the carriage, and such carriage was understood to involve the navigation of ship a voyage. Consequently, FSO, FSU cannot be included in the definition of ship. There are contrary opinions and great doubts about objects like barges towed on sea voyages, purpose-built FSO, craft originally constructed or adapted as vessels for transportation of oil. The purpose of the list, which will be prepared by the consultation group of IOPCF, will be to assist the governing bodies of the 1992 fund to decide on a case-by-case basis whether the vessel in question was a ship under Article 1 of the Convention or not. We can pause here and reach a preliminary conclusion. It is clear that the members of the ship industry are using the definition of ship as a barrier, a shield to limit the shipping world and to exclude that unknown, mysterious, and partially terrifying world where the offshore installation work. There have been two recent incidents which have triggered important initiatives. 2009, the incident of Montara offshore oil platform located in Australian exclusive economic zone in between Australia and Indonesia. 2010, the incident of Deepwater Horizon, a semi-submersible drilling rig which exploded, caught fire and sank in the Gulf of Mexico. Indonesia put forward to the IMO legal committee a proposal to add a new work program to address liability and compensation for oil pollution damage resulting from offshore oil exploration. After some initial reluctance, eventually IMO Council decided that they are not willing to take up the issue, but are simply encouraging regional or bilateral arrangements which are preferred through a truly IMO initiative. Can I conclude?
Yes. Quickly.
Very quickly. These events have, on the contrary, determined an important activism from a European unit. European offshore interests are present in North Sea, Mediterranean Sea. The European Commission launched an important research on civil liability and financial security, which can be found on the website of the Maastricht European Institute for Transnational Legal Research, reaching the following conclusion, which I would like to express just before concluding. There is no international legal framework dealing with liability for offshore-related incidents. IMO will not take action in this respect. There are only regional arrangements related to offshore safety, but most of such arrangements do not contain provisions with respect to liability. The two directives and the recent directive 2013, number 30 of European Union on safety of offshore oil and gas operations, particularly dealing with the granting of licenses, but do not contain a discipline on liability. Italy has tried to introduce, and implement into our legal system the directive of 2004, is still working to implement the directive of 2013, but the work to do is still important and challenging. Problems are enormous, and so are the challenges which must be faced. Harmonization, the issue of insurance, and last but not least, the comment which I would like to make, which is the following. The contribution of the P&I clubs and of the players of the shipping industry could give an important support given their experience with claims handling and prevention matters. The players of the shipping world, in my opinion, rather than concentrating all their efforts and energies in the defense of the frontiers of their world, would probably be more useful by putting their experience at disposal of the new world of the offshore industry. Sorry for being so long.
Thank you very much. This is really, Maurizio, this is really a complicated and very interesting subject. We should be spending hours on these things. The definition of the ship, is it by type, is it by operation, is it by what? So the important thing is that the message you are delivering is that whilst, say, insofar as pollution particularly, say the system, shipping, has already responded adopting conventions and limitation regimes, but compensation regimes at the same time, which is important because here we're not talking of defending, but we're talking also of offering protection to states and to third-party damaged parties. So shipping has already responded. The offshore, the real offshore industry hasn't yet. And say, I think your call, Maurizio, to pay more attention to what the shipping world has already done, it's really great. So thank you very much.